I'm really excited to be presenting today because I hope that maybe I can help you guys get records for a little bit cheaper, as well as helping an incredible organization that really needs our help right now. So if you are able, make a donation. Anything you can helps, any amount. So with that, I'm going to go ahead and share my screen. Okay. All right, so what are we going to be discussing today? We're going to be talking about how to get the lowest cost medical records for your clients. Now, I understand that with everything going on, how frustrating it can be to get that insane invoice from PsyOx when all you're trying to do is get the medical records to prove your client's case. So I hope that at the end of this, you will at least feel like there's some path forward. Now, I plan to leave enough time for questions at the end. So if you have questions as we go along, feel free to put it in the chat and I'll get to it at the end. All right, so let's get to the good stuff. So I do think that this is actually my fourth time giving this presentation. And I will say that each and every time that I do it, there is a completely new regulation or guidance that we have to deal with. So to understand how to get the lowest cost medical records today, we got to go through a little bit of history. So first, I'm going to take you guys through a brief overview of the HITECH Act. Then I'm going to tell you how everything changed in the wake of the decision in PsyOx via czar. And then finally, I'm hopefully going to give you a little light at the end of the tunnel by discussing the Cures Act, and giving you some methods and problem-solving solutions to still try to get the lowest cost medical records for your clients. Now, just a brief disclaimer before we get started, I'm going to give you guys my step-by-step process that I use in our nursing home practice to request records. It is by no means the only way to do this. It's just the way that I've found it to be most successful through a lot of trial and error. Now, all that being said, I'm going to assume that the vast majority of you guys are going to fall into one of a couple groups. The first group being people who know all about HITECH, PsyOx, and even the Cures Act, and have been using these requests the whole time to still get invoices for that $6.50 rate. Now, the second group of you used to use HITECH letters and maybe were getting that $6.50 invoice until recently, and are kind of wondering what's going on and are maybe a little bit in the middle of the road there. The third group of you may have never heard anything that I'm talking about right now, or maybe you don't even request the records yourself other than you send it to somebody to request. So I hope that at the end of this, I can get a couple of you from those last two categories into the first. All right, so let's start with the HITECH Act. And this is what I refer to as the good old days. This is when, for an extended period of time, we were able to get low-cost medical records for our clients using a very simple request. So what is the HITECH Act and why should you care? Well, it was passed in 2009 as part of the American Recovery and Reinvestment Act. And what it did was it modified pre-existing HIPAA regulations. If you remember, before HITECH came into play, we had to send a HIPAA authorization along with the request. And after HITECH, that was no longer required. And it really did something very simple but groundbreaking. It required healthcare providers to give patients a copy of their electronic record at a reasonable cost. Now, these are a couple of things that I like to refer to as the HITECH high points. The first and most important part is that you have an undeniable right to your medical record, and it has to be provided in the form and format requested. So if you request your records to be sent on paper, they have to send it to you on paper. If you request that it go to a CD, then they have to send it to you in a CD. You can ask for a summary, and that goes on and on. They have 30 days to produce the records, and the most important part for our purposes is that High-Tech said that they must provide records to a third party if one is designated. So a third party in this circumstance would be us, the law firm. So if a High-Tech request says, me, Avery Adcock client, wants to send my records to senior justice law firm, then that's what they had to do. And that the same third party authorization also applies to any records company that you use to request the records. The other really important part about High-Tech is that it said that the providers can only charge a reasonable cost-based fee, which can only include three things: labor for copying, which we're going to talk about, supplies, and postage. So the supplies would be the CD or the thumb drives or whatever you are requesting the records to be sent on if you want them to be sent that way. And the postage would be if you're requesting it to be mailed. And there were very few exceptions to High-Tech. It doesn't apply to certain psychotherapy notes, doesn't apply to information that's compiled in anticipation of civil or criminal litigation. And there's a couple of other limited grounds, but basically it applies for our purposes to pretty much every request. All right, so 3 ways to determine labor costs. And I apologize, during the pandemic, I've been watching a lot of The Office and Schitt's Creek, so you're gonna see a lot of that throughout the presentation. So High-Tech said there's only 3 ways for providers to determine what those labor costs are: actual cost, average cost, or a $6.50 flat fee. Now, the actual cost is the actual labor cost in producing the request. So for example, if the medical provider paid someone $10 an hour and it took them 30 minutes to complete the request, the labor cost of that would be $5 plus 20 cents for the CD or whatever it was. And what the medical providers found out was that it was never cost effective for them unless you were asking for a very cumbersome request. So one of the examples I like to think of is if you're asking for only records that mention asthma in the last 10 years. The other way that they could calculate labor costs was using an average cost. So if MedStar, whoever it is, wanted to take the average of all of their requests during a month, they could use that as their average. The other way that they could do it, and what we saw most providers doing, was using a flat fee. And the reason they did this is because it was the most cost effective for them and they could actually charge the most amount. So this is the old High-Tech process, and a lot of this still applies that we'll talk about, but I'm going to go through it really briefly. The first step in the High-Tech process was sending that simple High-Tech letter. The second step was trying to figure out whether or not they complied with High-Tech. And the way that we all know we would know that is if we would get a crazy invoice from Ciox or another company charging for retrieval fees, per page rates, all these other things. The third step would be to notify the covered entity that they are being non-compliant. Now, the covered entity is just a fancy word for a medical provider in this case. And a business associate would be the person who is, or the company who is fulfilling the request. So in most cases, in particular for DC, it's Ciox. And the fourth and final step, which I did in a ton of cases, is filing a complaint with Department of Health and Human Services. And we're going to go through each of these. So this was the simple High-Tech request that we used and we were able to get our records. And the key to High-Tech success was having a very simple request that is in writing, signed by the client, and designating where the client wants their records sent. So in this one, it's just saying, hey, records custodian, I want my complete copy of my medical records and billing statements in PDF format and send it to my law firm. It's very important today, and it was when High-Tech first came into place, that you use very plain identifying correspondence. So plain white paper, plain white envelope, no law firm letterhead or no law firm envelope that would allow the medical providers to see that it's actually being sent to a law firm or the request is coming from a law firm. All right, so did it work? Most common violations that I saw with high tech, and I still see, charging other fees. So a lot of times, if you look at the actual invoice, you see something that says an access fee, an inventory fee, or a labor for reviewing request. All of those things they were not allowed to charge. Requiring a HIPAA authorization. In practical matters, I still ask for one because it allows us to do a lot of other things, but you don't actually have to send that along with the request. So one of the big ones that we see and we still see today is when a business associate violates high tech. And the High Tech Act specifically says that any cost that that medical provider has in outsourcing the function of responding to request, that can't be a basis for charging that to the individual. And by far, I think that the most common violation that we saw was billing per page. So it specifically says even if they have to scan paper records into electronic version, they have two options. They can charge that $6.50 flat fee, or they can charge the reasonable cost-based fee for the actual labor costs. And for anybody who's not, who hasn't looked at the HHS's website about this, they have a really great frequently asked question page that goes over all of this in detail and gives you real life examples. So one of the biggest things is that they aren't off the hook if they only have paper records. What we saw and what we continue to see is that a lot of the providers who are bigger hospitals or larger facilities, they know what high tech is. They know what, you know, the Cures Act is and other stuff we're going to talk about. But some smaller facilities that's, you know, a mom and pop rural podiatrist, for example, or someone like that, was saying that they only have paper records and they can't respond to the request. So what high tech says is they don't get off the hook for that. They don't have to buy a scanner, but they have to send it in the format requested. And they can only charge you the labor cost for actually scanning it and the time spent in doing that. All right, so if your request didn't work, the first kind of course of action was sending a letter. So what I did and what I still do today, and I'm happy to provide any of these letters to anybody who wants to see them, is to try to resolve the issue first with the covered provider. So basically, I would send them a letter saying, hey, you're violating high tech, and include why. And now my letter incorporates some other language from some recent statutes that I, again, can send everybody. So if it's coming from PsyOx, I would usually send to the business associate as well as the covered provider, who would be the medical facility. And it basically says, hey, you are not complying with high tech, and that if you don't adjust your invoice, then I'm going to file a complaint on my client's behalf with Department of Health and Human Services. One thing I will say, if it's a larger hospital or someone who I've dealt with before, I don't send the letter to the records custodian, I direct it to the Health Systems Council. And what we see and what we continue to see is a lot of major facilities actually have counsel that their name is high-tech compliance specialist. So they know what this is and they know that they're violating it. Here, I did a little snapshot of what would happen if you file a complaint with Department of Health and Human Services. So there's a link to do this, and it's really easy to do it online. And basically all you do is include the request that you originally sent, the letter that you said saying, hey, adjust your invoice. And then Department of Health and Human Services does their own little investigation. And in 99% of the cases, actually, I think 100, we get records the next day when we file a complaint. We're going to talk a little bit about this later on, but this process of filing a complaint with Health and Human Services, this still exists and your clients can still do this today. So what I like to do after I've filed a complaint with HHS is follow up with something that I like to refer to as I told on you letter. So it basically says that this firm's been retained to represent, in this case, it was someone on behalf of a state, and that I filed a complaint with you for charging a per page electronic records fee. So in this circumstance, they charged me over $1,200 for electronic records. After I sent this and filing a complaint, I immediately got the records, because what you find is that after filing enough complaints with HHS, that if a facility has done this a lot and they've had a history of non-compliance with this, HHS is much less lenient than that rural podiatrist. So unfortunately, a lot of times you have to go through this process, but I hope that if you start doing it the way that I do, you might not even have to go through any of this. All right, so this brings me to Ciox via Czar, and this is the point when everything changed. Now, I still remember the day when this was posted to the listserv, because I had so many people calling and sending it to me saying, what does this mean? So there's a couple of important things to keep in mind to really understand what led up to Ciox via Czar. So after Congress passed the HITECH Act in 2009, a couple of major things happened that led up to this case. So in 2013, HHS passed what the court refers to as an omnibus rule, and it said two things. It first said that the fee cap applies when the patient requests records either in paper or electronic format. And it also said that even if you request paper records, the fee cap still applies. Now that implementation is now gone. A couple years later, in 2016, HHS passed another rule called Privacy Rule Guidance. And what HHS said during that is that what we've relied on for the past 4 years, the fee limitation and the patient rate, apply when the patient wants those records to be sent to a third party, aka us. So what happened is that after HITECH was passed, all these business associates, Ciox, Healthport, whoever it is that contract with the healthcare providers to handle their medical records requests, needless to say, they were not happy. So they went from being able to charge hundreds of dollars per request to $6.50. And actually in the Ciox decision, they talk about how it impacted their bottom line, that they were losing millions of dollars a year. All right, so Ciox via Czar, this came down at DC District Court, January 25th of this year. And now looking back on it, honestly, it was kind of an omen to the rest of how 2020 would go. And up until this point, the vast majority of us were getting records for $6.50 using the HITECH request. So what happened in this case? Well, Ciox brought the case under the Administrative Procedures Act. And full disclosure, I know very little about the Administrative Procedures Act other than in order to, sometimes you have to have a notice and comment period and sometimes you don't. And it depends on the type of action that the agency is taking. So in this case, HHS. And essentially what happened is that Ciox said that HHS didn't follow proper rulemaking when they issued that 2016 privacy rule guidance, and that they didn't issue a notice and comment period when they implemented the rule. HHS said, hey, we didn't need a notice and comment period for this type of thing. It's fine. Spoiler alert, the judge agreed with Ciox. All right, so what does this mean for me? Well, the key takeaways from the Ciox decision is that it vacated the third-party directive within the individual right of access. So what does that mean in plain English? Well, it means that the HITECH fee cap still applies to patients who request their own medical records, but does not apply to medical records sent to a third party, which would be us. So it's important to note that the ruling didn't say anything was inherently wrong with the fee limitation, but only that HHS didn't follow the proper procedure when they promulgated the rule. Another important part of the case is that it said that OCR would continue to enforce the right of access provisions, which means that clients can still file that complaint that we talked about earlier. The decision also said that only electronic records are subject to that patient rate, which in our practices isn't a huge deal because most of the time we would want electronic records over paper records anyway. So is there anything good in this decision? Well, in the decision, Judge Mehta said that the labor cost in preparing the electronic information for copying cannot be included in the labor rate. So what we were finding is that a lot of providers, when they were sending us our invoices, were charging those very high labor costs. Like they were saying they get paid $500 an hour to fulfill the request, which, in that case, let's all take up a job with SIOC. So that would be finding the records, sorting the records, putting them in the right format, anything that's getting those records to be transmitted to you. And what the decision said is the only thing they can charge is the actual time spent in copying the records, which should be minimal because you are essentially burning them onto a CD and putting the CD in the mail, or you're uploading them to a portal and then your patient is downloading them. Okay, so that brings us to the Cures Act, which is hope at last, or at least we think for now. Okay, so I know a lot of us have been hearing about the CARES Act, but there's another similarly sounding act called the Cures Act. So this is another HHS regulation that was promulgated from their authority in the 21st Century CARES Act that's been around since 2016. So the final rule was posted in the Federal Register on May 1st with an effective date of 60 days later, which would be June 30th. So the enforcement compliance date was originally February of 2021. But essentially what happened was that medical providers, because of everything going on with COVID, they said, we have too much going on. We don't have enough time to, do everything we can to comply with this. So they've extended that deadline twice. So the current deadline is April 5th, 2021. So that's why you might be seeing on the listservs where some people are saying, can we not get third-party requests now? Is high tech not back? But in reality, up until April 5th, clients are going to have to order and receive the records and then send to our office to get the lowest cost for those records. However, theoretically, under this new rule, our office or whoever is doing your medical records request should be able to sign up for electronic portal access and download the records at no cost. And here I just included a table that again is on HHS's website about the different compliance dates and what they are. But I'm happy to send the actual information to anybody who wants it. Now, it also said that this only applies to electronic health information, that it doesn't apply to physical media. So paper copies, a CD, flash drive may still be subject to a fee that wouldn't violate the information blocking provision. So what does that mean? So essentially in this act, it said that it's prohibiting medical providers for charging more than the patient rate. And it said that any request for electronic access to records is subject to the same patient rate, regardless of whether it's from a patient or from a third party. So, we found in SIOX via czar that essentially that part, the patient rate going to a third party, would be now extended. So it seems to invalidate it. What it also talks about is a concept called information blocking. And it says when SIOX and others charge crazy fees, it's a method of interfering with access of information, and they can't do that. So one of the other things that is important, I think, about this act is that it also includes a new audit trail standard for any of you who use them in any of your medical malpractice cases or whatever case you may use them in. And it specifically talks about what has to be included in audit logs. And it says that the date and time have to be included, including the access events, the data activities, how long the person was accessing it, the type of action, whether it's they're creating data, deleting it, changing it, whatever it is. And they have to include that unique patient and health information system user identifier. So that is good. Okay, so problems that people are talking about right now. So a lot of those who are interpreting the new rule say that there are loopholes within the act that they expect SIOCs and others to try to fight. Now, if we're being realistic, SIOCs has been fighting this for years to come. And I think the reality that they're just going to lay down and say, well, I guess now attorneys don't get that 650 rate is low. However, there are things we can do to try to get around that. One example of a loophole that a lot of people are talking about is that it says that records produced with no manual effort have to be provided to patients and whoever they designate free of cost. But a lot of people are asking, what does manual effort actually mean? And that if SIOCs and others start litigating that to say it involves manual effort to do this, then we might get those excessive requests again. I included this just as an example of some things that people are doing. This specifically is an AAJ letter that they've posted, and it's a way that they are responding to the new regulations. And basically, it's a letter saying, hey, SIOCs, you are not only violating high tech, but now you're violating the Cures Act, and it has all the information there. In my experience, the best way to get the records as fast as you can is to do it as if the patient is requesting the records and not including any of this legal jargon, because when you do, they obviously are, more in a fight mode than if it was just from the patients requesting themselves. And we'll talk a little bit about that. Okay, so can we still get low cost medical records? Well, the good news is that I think we can, but the bad news is I think it makes our jobs a little bit more difficult. So the main thing we have to figure out is how to get those records via patient request without any third-party directive, which would be saying send the records to the law firm. So to get the patient rate, the request can't direct the records to be sent to a law firm. It has to truly be a patient request. So where we see an impact and where you want to do this, and again, it really is a practice by practice basis, is where cases where you're seeing that really high invoices. So, in our practice, if it's a hospital or any DC case, we go through this process. We don't do it for, EMS records or other kind of smaller requests. But if it's an extended history, and definitely if it's a DC case, we do go through this. Otherwise, you're going to be paying the state rate. So I just included this to give everybody an idea. I know that we all practice in DC, but a lot of us, when we request records, the providers we're requesting from are located in Virginia and Maryland. And as we all unfortunately are aware, right now, DC's medical records statute just says that the provider can charge a reasonable fee. And that's why, particularly in DC, we're seeing these insane invoices. And this is all for electronic records. Virginia is a little bit better because it has a 150 cap. Maryland is around the same, but you're never going to get that $6.50 rate unless you go through these steps. All right, so we're going to talk about each of these in turn, but I want to briefly just go over everything. So the first thing you're going to do is modify your retainer fee agreements to allow us rights to access these records. The second thing you're going to do is set up a new client email, or if the client wants to, you can have the records sent to their email. Or you can request it through an authorization, which I'll show you. So the next step is going to be doing what we've been doing the whole time, sending the high-tech letters to the providers by mail, fax, or using their own authorization. And then the last step is that when an email notification is sent by the medical provider, we access it and download the records. All right, so I have included what we put in our retainer agreements, and it basically says that I understand that my lawyer and their staff have to collect my medical records in order to prove my case, and that I'm allowing my attorney to access my records through any provider portal or through any email links sent to me. So what I usually do is during intake, I explain to all my clients that, listen, we have to request records, and that the only way that we can get the lowest cost for those records is by doing it as though they are requesting the records, and that ultimately that is a case cost that is going to come out of their case. I then explained to them that they would have dual access to the email, but that I recommend that we create a new case email for them. You'll see that you can have the records sent to your client's home or their email address, but obviously there's a lot of issues with that, and you have to assume that you have a responsive client that's going to forward you the emails. I will say that 99% of the time, clients are totally fine with setting up a new email or Dropbox link because they don't have to do anything. And a lot of times it actually helps them because they use that to Dropbox documents or whatever they would that's specifically for the case, other than having to send it directly to me. All right, so the second step again is setting up that new client email. So during intake, we have a practice that we set up, and this is just how we do it. Again, you can do whatever you want. That the email is first name, last name, date of incident @gmail.com. And then if you want to, and if you don't have to do this because this is another step, but in my opinion, it makes it a lot easier. In that email, whoever's doing this, you set up a rule to forward all mail to, in this particular instance, we use nursinghomerecs@seniorjusticelawfirm.com. So that's what would happen if you were doing it through setting up the client email. Or again, you can instruct the client to forward the email download from their personal link. Or I have seen records being sent to a PO box that is actually the law firm's. A lot of people have had success with this. Obviously, during COVID, that's just a whole nother thing to have somebody going to the PO box to see if they got an email. But there are a lot of workarounds around this. But it's really important to explain to your clients that they're not going to be doing anything. You are going to be doing, all the requests are going to be the same. It's just that it's going to be coming to the new case email, or alternatively, one of these other options if you were to choose one of those. All right, so the third step in this process is sending the actual request. And again, you are drafting the letter. Your office is drafting the letter. You have the client sign it, or what we do is we just have a client sign a regular authorization and use their signature. And then you send the request. So right here is the request that we use if there's not a portal link to download, if it's not SIOX. So here you include all of this, and where it says, please send my records to my email that is where you would put that new client email, or alternatively, if you wanted to use the client's personal email. And all you do is mail or fax this request to the provider. Now, I will say it's more important than ever to make sure that this request is as simple as it can be. So your goal in all of this is for whoever is responding to the request to not know that it's coming from a law firm. So a lot of times what happens is that if you send a blank request on a plain white piece of paper, but then you include your fax cover sheet that says Senior Justice Law Firm, well, they're going to read that and they will process it as an attorney request. The other option is that you can use the provider's authorization to request the electronic records to be sent. So I'm going to show you guys, if I can. Let's see. An example of one of these. And I can actually send this to everybody at the end because I think it's probably a little bit easier to do it that way. Any request that you go to, any online, whether it's MedStar and you just type in medical records, it's going to have the actual request on there. And all you have to do is click the box that says, I request that the copy be provided on paper, through a web portal, whatever you want it to be. And what I always prefer to do is click the box that says through a web portal where possible and provided to my email address at this account. And this is a link there to do that. But again, I can send everybody that. And a lot of the times it is easier to use their own request, I've found, because you're not risking doing any of the things that make it non-high tech, such as, sending the fax cover sheet or whatever it may be. Okay, so step 4 is that an email notification is going to be sent by the medical provider to that address, and then we will access and download it. So what's going to happen is that after you request the records, so this is from Washington Hospital Center, this is an email that would be going to that client email. It's going to have an invoice number in there, and it's going to say, hey, you requested your medical records from Washington Hospital Center to be delivered electronically. You can now download them through the secure e-delivery patient portal. So, and then it gives you the link to download it. It is important to note that there will be another email that comes through that'll have a PIN, but what most of my clients do is literally just forward me this email when they get it, or my staff member says, we got the records and she already downloads them. It's really whatever your practice is and what works for the best. Okay, so when you get that email and you navigate, and for SCIOX, it's mrdelivery.scioxhealth.com. What you're going to see here again is this e-delivery platform. And this is what people are talking about with the patient portals. So it really is a very simple process. You put your invoice number in, you put the PIN in that you got in that email, and then you will get taken to the next page that actually has the records, the invoice, and all the information, and all you do is download the records. Now, this is a little bit different from MyChart. A lot of people talk about MyChart, and if a facility has it, it's great to use that because you can request records through that. But if the client doesn't have a MyChart set up, I think this is the easiest way to do it, but you can also request records specifically through MyChart. So the best part about this is that at the end of this, you're going to get something from SCIOX, your client will, that says your medical record request has been delivered electronically to your SCIOX e-delivery account. And as you can see, the only thing that they charge my client in this case is $6.50. So it really does work. You know, I will say that a lot of people, you know, when they hear this presentation, they're like, oh my gosh, she's saying that I have to include a whole nother step in my process and I don't have time for this. The reality is that at the end of the day, it really does work and it saves you a lot of time and money in the long run by doing it. And once you set up a process, then you are able to do that. So I'm going to see if there's any questions. Let's see. Anybody has any questions, they can put them in the chat. Okay. So one question, and I'll just go through some that I get a lot. One question that I get is what happens if the person is deceased or has a guardian or power of attorney or whatever it may be. And it actually says in the regulations that that personal representative should be treated as though they are as the individual in this case. So one of the other big questions I always get is who pays the invoices in these cases? So, you know, when the client gets that $6.50 amount, the safest thing to do would be for your client to pay the invoice and then you know, write them a check. But I understand for a lot of reasons that is just too burdensome and cumbersome for, you know, a lot of practices. In reality, the person who is fulfilling the request and who is actually doing the invoicing a lot of times is different. And so if your firm pays for it, there's nothing in any of the records or the acts that say who can pay for the request.
Avery?
Yeah.
Let me see. There are a few questions in the Q&A, and also Dan Cosma has his hand up. So I'm gonna, Dan, if you still want to ask your question, I'm gonna allow you to talk right now. Whoops, should have worked. Yep.
Can you hear me?
Yep.
All right. What I was wondering is, can we get copies of these recommended letters and the language for the retainer agreement and that sort of thing?
Absolutely. Yeah, I can send that to everybody who's on this webinar, and any other things that I think of, I can send that to everybody. Because some of the requests are different. I have one that if somebody's deceased, I send, and I have one if somebody's alive and a power of attorney and all of that stuff, but I'm happy to share that with anyone.
Thank you.
Okay. And then Avery, do you see the Q&A?
Yes. Okay, let's see. So I see one that says, can a law firm's mailing address successfully be supplied as the patient's address in a records request by the patient? So this is something that I've seen a lot of people do. You know, my best advice is that if it's working for you, then keep doing it. But at some point, they're going to catch on. But I have seen a lot of people do that. I've seen a lot of people use the PO box and not say senior justice law firm, but put, you know, whatever the address is. And it's worked for them. So, you know, I would use it and see what happens. I will say that, you know, a lot of times when you try something that they figure it out. So I would just do it until it doesn't work. And let's see. So there's a question about when you talk about the online portal, do you mean setting up a SciOx e-delivery account for each client or setting up a MyChart account for each client? Can you explain the process for this? Okay. So when you, let me see, Mary, can you tell me if you can see this authorization on the screen? Or is it just my PowerPoint?
I just see your PowerPoint.
Okay, let me share. Hold on. All right, let's see. All right, can you see that now?
Yeah.
All right, so this is a Hopkins request that covers obviously a lot of the providers we're talking about. So one of the options you can do is instead of sending that regular request, you can use their authorization to do everything we're talking about. So what you would do is fill everything out that you normally did. And right here is the important thing. So you say, I request that the copy be provided where possible. What I always like to click is right here through a web portal with notice provided to my email account at, and this is where you would put the email address that you want it to be sent, whether it's a new client email or their personal email. You can also do that it's sent by email just directly to the email address, but it's a little bit better to do it that way because you get it encrypted, with you have to put in the date of birth and all of that. And then towards the bottom here is where whoever is signing. So if it's the client signing, you're putting the representative, and then you click here, whatever the authority is, if the person is signing on behalf of the client, and include that. So for example, in my practice, if I say request Hopkins records, then they just fill out this authorization, include our new client email there, and send this off with whatever we need from here. And then we get the link directly to the email account. My chart is a little bit different just because it doesn't have access to the full medical records. Usually it's just the summary that you can download, but it's great to use if you have a client that has just been in an accident, and maybe he doesn't know, the dates that he was there, but then you can also go through the My Chart and request records that way. A lot of times why I say it doesn't work as well is that the activation code has expired and you have to do a whole new activation, but you can also do it that way. Let's see.
So Avery, go over to the Q&A, not the chat. The Q&A has a bunch of questions.
Okay.
You see it at the bottom?
Yeah, I see one from Zachary. Is that the one I'm supposed to be looking at?
Yeah, but there's some, if you scroll up, there's some starting at the top. Do you not
Okay,
see?
so there's one about, do you know which vendor provides the records for a particular facility?
Yeah.
So I'll tell you that Ciox pretty much does all the MedStar records. They do, if you're looking here, this is GW's, and GW's website is interesting. I think it really is worth the time for a new provider that you're requesting from to go through their website and see what their portal is. Because, so for example, GW uses Ciox, and it specifically says here what you're going to be charged. So it says patient fees. So this is what the patient gets, $6.50. But if you go down, this is what we get: the attorney's fees, the preparation fee, and then the per page fee plus shipping and handling. So, I think going through everything to see exactly who it is really important. But I will say that pretty much everybody in DC uses Ciox with a couple of exceptions. So let's see. Can you forward the copy of the complaint letters? Yes, I will definitely do that. Instead of using our client's email address, can we set up a generic email address, something like My Medical Records? Yes, absolutely, you can do that. If you have, and I actually think that's a really good option for a high volume practice when you're getting a ton of requests in. The only reason that we have separate emails now is that you can specify who is the request for, so whatever client. So Nikki asks, I've tried writing letters to Maryland legislators to change the law, no response. Is there any organized efforts by lawyers to do change to the state laws recharges? So I will say that I have been involved with both Virginia and DC's effort on this. And what has happened is that when specifically DC and Virginia, when they were working to change all the medical records laws on this, high tech came into place. So, people were pretty much like, okay, well, we don't need to spend our money here because we have a federal law that says that you can only charge this for fees. But now they are working on trying to get new legislation passed that includes some of those statutes that actually mimic the High Tech Act. Hopefully, with the Cures Act, when it goes into place, finally in April, that we'll have a little bit more guidance. But in the meantime, there is efforts to actually pass legislation that mirrors the High Tech Act until that happens. Let's see. I think that's it.
Yeah, I think that might be it. Does anybody else have any other questions? It's been such an excellent presentation. Okay.
But honestly, I'm also happy to, if anybody has a question later on and they want to email, I'd definitely happy to go over that as well. Because I know a lot of times questions come up later, but I think that the more that we all work together on this, and maybe even like develop a database within your own practice, or whatever it is, to say, okay, this provider has electronic records, this is their business associate, this is what I've gotten records for, that we can all work together and try to get the lowest cost records for our clients, because it's really, it's not their fault. They were in an accident, and the only way that they can prove their case is by getting these records. So if we can try to do a little bit against PsyOx, where they're definitely taking advantage of our clients, I think I'm all for that. I think we have one more where they said, so we have one that said, are there any good cases that define a reasonable fee under state level laws? So, I am not aware of any in DC, except for there have been a lot of groups. I know there was a class action over that. And again, they're trying to pass new legislation for what is reasonable. But I think that the fact that there's not concrete case law saying this is reasonable is the reason that we're all trying to, get something new passed. But if you find any, definitely send it to me.
And yeah, in Q&A, there was one more question from Demi. You see it?
So I think it says, I think you suggested not using legalese when a patient requests the records, although your sample records include the code sections. Should we include the law in our letter? So, when you're sending out the initial request, I think that the best thing to do is, include the high tech code section, but don't include all the other stuff with it, because a lot of times that does really, put them on to, this is coming from a law firm. The problem becomes when so say, you request it through a client, and then they send a non-compliant invoice. Well, the responses to that about why they can't charge a retrieval fee and all that, they almost have to be legal. So, at some point you're going to kind of show your cards. So, honestly, I think it's what I have found, that the best way to get records is using a very simple request that literally says, in layman's terms, I was the child of a patient who was at your facility here. Please produce the records in electronic format per the patient rate. So I have trouble following up on requests via phone because the HCP asks if I'm calling from an attorney's office, then if the firm's name is not used on the request, they will not release any info. They say that the patient themselves must follow. Is there a way to get around this? Is there a better way to follow up? So yeah, that's one of the problems with doing it this way, except for through the portal. Because through the portal, you're going to get the records if they have the patient portal to request it. If you're sending just that form request, then you're going to have to do this follow-up where, yeah, you're calling to say that. But at the end of the day, you know, if it's a big enough case that, you know, you're doing this for, then you can always have your clients call. Because yeah, I do think that if they're asking if you're calling from an attorney's office, you know, everybody's different. I would feel a little bit uncomfortable saying, no, I am the client, and I would probably just have my clients do that. But, you know, if that's happening, then I would also just have a form that you have that is sent from your client that says, I'm following up on this request. You had 30 days to do it. And I'm going to file a complaint, because your clients can still go through that process of filing the complaint. And in most circumstances, because they know they will get fined, they will give you the records right after you do that. Okay.
Okay, I think that's it, Avery. Thank you so much for this excellent program. I think everybody on here just saved a whole bunch of money.
Well, thank you.
Okay, so with that, we'll sign off. I sent your information in the chat to everybody. It's more towards the beginning of the chat if anybody wants to go ahead and copy and paste that. If anybody needs to get in touch with Avery and didn't get that information, go ahead and email me. And with that, I will wish everyone a happy Thanksgiving, safe and happy Thanksgiving.
Thank you, everyone. Good luck.
Thanks, Avery. Bye-bye.